Good afternoon. Artificial intelligence in the law. Wow. It's a whole new ballgame. And the last year and a half, we have seen things that we never dreamed of. Really, the ability of especially generative AI to produce images and art that are just hard to imagine sometimes. So part of actually what we see, looking at this from a legal standpoint, is that there are people like Alex who embrace some of these technologies and find them to be an important part of their creative process. But there are other artists, visual artists, who are very upset about generative AI, and there are now 24 lawsuits that have been filed against generative AI developers. And of course, part of what's interesting is how much the members of the public have decided to use these generative AI tools to produce images, and how much they feel that there's a new tool for them to become creators also. And so we have a very complex ecosystem now with generative AI, and that's part of what we want to talk about today. So I'm going to make a few remarks about the lawsuits that are pending and also other legal initiatives in the US. And then Gerard will talk a little bit about some of the developments in the EU. We have a few questions back and forth, I think, to talk about as well. But I'd like to make sure that we leave some time for you to ask your questions, because generative AI and copyright seems to be something that everybody has an opinion about and questions about. So this is an opportunity for you to ask something that you want to know something about. So there are, as I said, 24 lawsuits that have been filed so far against generative AI developers. Some of them pertain to music lyrics, some of them pertain to computer software, some of them are about books, and some of them are about visual arts. There are 3 lawsuits against makers of image generators, 2 against Stability AI, one brought by Getty Images, which says that 12 million of the images that it has on its websites have been used as training data and without a license, and a class action lawsuit whose lead plaintiff is a woman named Sarah Anderson. That Sarah Anderson case also involves Midjourney and DeviantArt and Runway as defendants. So there are plenty of people out there. And just this last month, another lawsuit was filed against Google for its image generator. And all of these lawsuits actually, the image lawsuits are based on training on a data set that was created by a German nonprofit organization known by its initials, Leon. And that data set consists of something in the neighborhood of 5 billion images that were found on the internet. And one of the things that I'm going to be interested to hear from Gerard is whether, because of the text and data mining exception to copyright rules in the EU that allows making copies of works for training data purposes, and nonprofit organizations can do this even if somebody wants to opt out. There is a no opt-out provision, at least of that particular thing. So if it's lawful to do that in the EU, is it lawful to do it in the US? Well, of course, the generative AI companies say, of course it is. The stuff was found on the open internet. So that's going to be one of the bones of contention. But I think it's going to be interesting to see what happens with the lawsuits. The main defense that is expected to be raised in the generative AI cases pending now is fair use. And during Q&A, I'm happy to go into kind of what does this look like from the standpoint of the plaintiffs who think no, it's not fair use at all, and what does it look like with the defendants in terms of what they think the case law and the law really should be understood to do. And so we're going to talk about, again, some precedents if you're interested in that. But the number of lawsuits that have been brought kind of suggests that the lawyers who brought them think that there's some merit to the copyright infringement claims based on training data. And just this last week, there was a hearing in the Anderson case in which the judge basically decided that the plaintiffs had adequately pled that there were compressed images in the model, and therefore that the model itself was an infringing copy. Whether that's technically accurate or not is one of those things that people will be arguing about, but there are two training data issues then, one based on the model and one based on just using the data set as to train the models to the first place. So many of the claims, many of the complaints include a lot of other kind of claims, including some claims about in the style of this particular artist, is that fair game, or is that something that's a copyright infringement or a violation of some other law. But right now, the cases are all in very early stages, and so it's really hard to predict how they are going to come out anytime soon. Now, one thing that's another recent development is that at least OpenAI has announced that it's developing a system to allow people who don't want their works to be used as training data to opt out. And this is largely, I think, in response to developments in the EU, because the EU has a rule that at least for profit-making entities that do text and data mining, that they have to allow copyright owners to opt out. And in terms of sort of other things that are happening besides these lawsuits, the Copyright Office right now is very, very active in this space. They've held some listening sessions about to allow stakeholders or other interested parties to say what they think should happen in respect of copyright and generative AI. And so those are available on the Copyright Office website if you're interested in taking a look at them. The Copyright Office also issued a call for public comment called a notice of inquiry last late August, and asked 30-some questions related to generative AI and asked for public comment. They got 10,000 comments from people, and so now they're plowing through them. I asked one of the people who's working on that, have you been using generative AI to try to analyze it? And the answer was no. But anyway, so the Copyright Office will be producing a set of reports over the rest of this year, at least that's their goal. The first one will be about the impersonation, deepfake, AI-generated false stuff. And whether legislation is needed or whether state or federal laws right now are adequate to address that particular issue. That's one that Congress had a hearing on relatively recently. And the second report will be about the copyrightability of AI-generated outputs. At the moment, the Copyright Office position has been that AI-generated outputs are not protectable by copyright law because there's no human author that does it. Just issuing a prompt or a series of prompts to generate an image is not sufficient authorship according to the Copyright Office position. Now, interestingly, one of the comments that was filed in response to this notice of inquiry was from the Motion Picture Association. And what does the Motion Picture Association do with computer-generated stuff? They put it in their movies all the time. And the Copyright Office right now not only says it's not copyrightable, but also says that you have to disclaim authorship. And so the motion picture industry is kind of asking the Copyright Office to rethink what it ought to be doing in respect of AI-generated outputs. So that's the number 2 report, and I think the number 3 report will probably be on the training data-related issues. And I dabbled in the 10,000 comments and saw that there were really quite a lot of different points of view being expressed. So it'll be interesting to see what the office has to say on that particular point. So that's kind of, Congress has held a number of hearings about these issues, and there are both, they're both bills pending in state legislatures and the federal legislature. So the one most relevant to the issues we're talking about today are the state of California has a bill now about disclosing the contents of the training data sets used in generative AI system development. And Adam Schiff in the Congress has been doing that too. And so while there are I think the last time I looked, 700 bills pending in state legislatures right now about AI. The ones I think that are most relevant to our discussion today are these ones about training data and disclosure, and that's actually a good segue to Gerard because the EU's AI Act actually has something to say about that too.
Good. Good afternoon, and thank you, Pam. I have no notes, so I just can speak completely freely, not hindered by any written instructions. But that's just kidding. I don't want to start immediately on I don't want to go to the detail immediately. We'll get there, but I want to make some just general opening comments first. And I think first is, and it's almost like I must say this, that the EU isn't just kind of keen on regulating AI or regulating anything that moves or technology, etc. I mean, we want to be a leader in AI. We are investing in AI. We want trustworthy AI. So we're putting as much emphasis. We won't talk more about it today, about making sure that the European Union isn't falling behind in AI, as it maybe happened on other technologies. That think about cloud, and then we put on the regulatory framework. But we think the regulatory framework is important because you need also legal predictability. I mean, we need to know what the rules of the game are, and there are definitely also risks. And this is one example of a risk, maybe not the risk that we're thinking about. I mean, we talk a lot about AI and the risk for is falling, and particularly these very powerful models falling into the hands of bad actors and how they could use it in order to make maybe chemical weapons or biological weapons. So those are risks, but this is also a risk that we undermine our own creative capacity and kind of not provide an opportunity to authors and artists and everything else just to also to make a decent living, because that is absolutely necessary for creativity to thrive. So that's definitely a point. I think the other point I want to make is that, I mean, particularly in this sector, don't just look at technology as a kind of a threat. There's huge opportunities. My daughter is a master's student in museum studies at San Francisco State University, and she will actually be graduating next week. And one of the areas that she's focusing on is how you can use technology in order to improve accessibility, to enhance the visitor's experience. I mean, people who may not be coming to MoMA here, but still want to enjoy the art that is available here in MoMA. So just don't look at technology as just only from the downside, from the risk. Just also make the most of technology, because there are tremendous opportunities here to improve access and kind of the experience for visitors and kind of spreading the cultural richness across also different segments of the population. That's the second point. The third point I want to make, I'm just coming from, I was at the Salesforce Tower, the top floor, which is lovely. Unfortunately, there was no fog, so it was a great view. But we had 4 days here with our High Representative, the Vice President of the European Commission for Foreign Policy and Security Policy. I call him the Anthony Blinken of Europe. His name is Josep Borrell, and we took him to technology firms. At the political level, we are here a bit more like, we don't have Senator Wiener here, who's incredibly competent, by the way, and we work a lot with him and other assembly members and senators. I was in Sacramento yesterday, and almost every week in Sacramento we talk about these issues, also with Senator Wiener. But it is important that at the political level there is this understanding about AI and what the implications are for our societies, for our economies. And this was more on the foreign policy and security policy side, but we need to do that same. Policy making is also always kind of 4 or 5 steps behind the market. Our ambition is always just to be no more than 2 or 3 steps behind the market. But if that's true for policymakers, you can think of the average politician. This is pretty scary. Put this issue of AI and copyright on the agenda of a ministerial meeting, and the ministers will run for a mile. This is incredibly, and then you add standards to it, and they will run even faster. So we need to get the political level also to be focused on these issues, because these are complicated issues, but incredibly relevant issues. Now, I'm coming closer now to copyright, and then like what type of framework we have in place. I'm now here. We opened an office this summer, will be 2 years ago, because we wanted to be very close to where a lot of the action is in Silicon Valley. We didn't know this was AI was coming. When I came, the issue was the metaverse. We were focused on the metaverse. Who talks about the metaverse nowadays? Almost nobody. And when I was talking about the EU AI Act, the answer was, well, why do you legislate? Europe, it's too soon. You don't understand it. You're stifling innovation. Don't do it. And then like a year later, of course, or not even a year later, kind of 3-4 months later, ChatGPT-3 came, and the world changed completely. And now when I talk to people about the EU AI Act, they say, well, why does it take you so long to put it into operation? So the conversation has changed 180 degrees on this. But maybe first to the copyright framework. Our copyright framework is different, slightly different. Well, it's more than slightly different than the US. And I've been in DG Connect in the European Commission before I came here. I've been there for 10 years. Part of my time I spend on the copyright digital single market directive, which was entered into operation in 2019. And I always go back to why did we put, say, then a whole framework? And this was a pretty traumatic experience. Copyright is not just complicated technically, but the interests are, it's almost a zero-sum game. When you're going to say, we were very much focused in, say, 2016, 2017, or what was then the value gap. That the authors and the artists weren't getting the money from the platforms. They were using the content and making lots of money from advertising, and they still do. And actually the artists, they didn't get the fair compensation. So that was actually the motivation why we legislated in the first place. But it was a pretty traumatic experience. We just got it through. This is not easy. Politically in the parliament, we won the vote by 10 votes. We got a majority, which was really a narrow escape. So here now we're looking again, I think, at similar issues, but we have a framework in place which is a bit different from the US. And when we talk about AI and the AI Act, yes, there is the AI Act. It's been agreed politically. It will be adopted very soon. Then it will enter into force 20 days later. So in a month's time, it should be in force in the European Union. And then there's a little bit of what we call in French décalage. So it will enter into force in stages, but 12 months from now. So say middle of 2025. Also the kind of provisions that apply to copyright should be in force. But that doesn't just set us aside from the US, where you have the state of California is working on regulation, but there's no real federal. There's a little bit of sectoral here and there, but there's no federal, call it baseline, on AI. But that's not the only difference between the EU and the US. We have a GDPR, the General Data Protection Regulation, I mean, you have a version of the GDPR here in California, and then a number of other states have, of course, copied that. So it's not that there's nothing, but at the federal level, there's nothing. I mean, there's a bit of children protection for privacy, but not much more. And then we have a copyright framework in place, which you don't really have in the US, at least not as expensive as we have. And so what's kind of relevant in this area, and this is what Pam already hinted at. I mean, we have a number of like provisions that, of course, at the time when we were drafting it, we could not have foreseen, this AI revolution. I mean, we didn't have that. We sometimes have a little bit of foresight, but not that much. And so but now, like, we are glad we have at least some of these provisions, and then we need to think, and I think one of the points I need to make is we haven't got all of the answers in the European Union, but at least we have a framework that can be interpreted and can be applied, and so because the thing we want to avoid always in the European Union is legal uncertainty. Also because we have 27 member states, and they might then regulate in different ways, and we don't like this idea that, I mean, we end up with litigation, and then every kind of the legal certainty will come from court decisions and jurisprudence. We think that it's important that, say, the political level, I mean, so at the European Union level, it's the European Parliament and the Council of Ministers, that they take their responsibility. They put in place a framework. And of course, then there can be some litigation in the context of that framework, but these answers need to be provided for by our political leaders. We don't think that judges should like take all of these decisions because of, like, in a way, the political leadership leaving a vacuum that kind of then has to be filled by the courts. We don't like that as a principle. Sometimes it happens in the EU, but it's not our preferred avenue. So what is relevant in copyright, and here we need to look also at the intersection between the copyright framework of 2019 and then the AI Act, which very soon will be adopted and then enter into force. There's two provisions that are very relevant here. And Pam already hinted at one, which is the text and data mining exception. I mean, we have a kind of general text and data mining exception, which is for research purposes. But if you do text and data mining and you have like a commercial perspective, then if you are because the copyright holder, you can opt out. You can kind of say, no, I mean, I don't want you to take my copyrighted material and use it. I mean, in this case, for example, to train these large language models or these generative AI models and use it. I mean, I don't like that idea. This is my copyright, and therefore I should control how it is being used, and I can opt out. So there's an opt-out clause that is being exercised. I mean, it's still, I mean, what is a little bit more complicated is how do you make it work in practice? Because there's one way of saying, look, you have the right to opt out, which is Article 4, Paragraph 3 in the Copyright Directive, and then making it like effective in practice and also easy in practice. So there's like ways now, there's standards being developed that make it easier to do so. But if you are a copyright holder, you can tell the large language model, I mean the OpenAI or Anthropic, I don't want my data to be used to train your model. That's one very relevant provision. The other relevant provision is in the AI Act, which came from the European Parliament, and it was a little bit of a scare here to some companies in this city. And that says, look, you have to be transparent about, first of all, you have to have a policy in place, like how are you going to respect copyright? And then secondly, you need to be transparent about how you have trained your model. What is the model, not in necessarily great detail, but at least it needs to be clear to copyright holders, like whether you have actually kind of trained the model on the copyright. And if you look at, like, if they train, we just had a meeting with Anthropic and Jack Clark, and of course, I mean, they train it on the internet, on all the public data on the internet. And there's a lot of copyrighted material amongst that public data on the internet. So what we're asking these companies to do, these developers, these deployers of these models to do, is to be transparent about how they have trained their model. And so they have to be clear that, yes, I trained it on this type of data, and it does or does not include copyrighted data. And the combination of the Copyright Directive and the AI Act and the AI Act particularly will help the implementation of the Copyright Directive, because of course at the moment we don't know how these models have been trained. So there's a lot we don't know. And so if these companies, when they have to have a copyright policy in place, I mean, it will make them mindful of the fact that there are obligations that they will need to comply with, and that helps. And then secondly, they will have to show, look, okay, this is how we've been training our model. And that, therefore, that type of combination between these two instruments is relevant. And it's relevant also because we are saying, look, if you are deploying your model in the European Union, these are the obligations you have to comply with. So even if you're in the US, you're training your model here in the US, if your model is accessible, because deploying on the market is a very broad concept in the European Union. It means if somebody in Europe can use your model, you're deploying it on the European Union market, and these are the obligations you have to comply with. And therefore, what it could enable, and this is now like where we see the future going, because of course copyrighted material is valuable. I mean, you should be able to get, I mean, either you decide, no, I don't want it to be used, which is, of course, your good right, it's your copyright. Maybe you don't want it to be used at all, fine. But some right holders will say, well, I want to get some remuneration for it because I made an effort. It's like my creative kind of activity, my kind of inventions, and I want to be compensated for that. And that's presumably where we will be going towards, some kind of situation where the right holders can, maybe in Europe we have a whole tradition of collective licensing as well, so they can be represented and they can then negotiate, because it's also easier to negotiate as a group, because these companies that you're facing on the other side of the table, of course, are not small companies. They have also some kind of a market power that you could say, okay, I mean, I'm okay if you use my data in order to train your models, but I need to be compensated for that. And then you negotiate what is the fair compensation for the data that you make available on the basis of which these models will be trained. So that's where we think we will be going towards, that kind of the right holders can either decide, no, I don't want to have anything to do with it, or they will go to a situation where they say, okay, well, but we need to be remunerated for that. But there's still, I mean, we don't know whether this is going to happen. And there are also questions, I mean, the question, I think the point that you made, Pam, that kind of in terms of, I mean, output, I mean, we have the same principle in the European Union. It's kind of, I mean, it's human creativity. You cannot copyright something that's produced by AI, but AI can assist. We were at NVIDIA 2-3 days ago. We had a meeting with Jensen Huang, the CEO, and they've got a fantastic demo room. And one of the first things they showed us was like Hollywood blockbusters. And they said, well, out of the 100 movies that kind of got an Oscar over the last few years, 97, 98 of them have been made with our AI, with our chips and our AI and all these like special effects and everything else. So hardly any movie nowadays is made without AI. So this is like AI enabled. But of course, you need to look on a case-by-case basis, like is it like the virtual paintbrush that kind of is just a paintbrush and it's still the painter that kind of makes it? Or is it really kind of where it's almost all AI? And say the human kind of creativity part of it is actually minimalistic. So that will need kind of an assessment on a case-by-case basis. I mean, at the moment, I mean, we're studying, I think, much like in the US, whether this framework is sufficient. Because of course, again, if we need to legislate, this takes time. We need a couple of years, I mean, because we do extensive public consultation, we do impact assessment, etc. We have a special way of making laws in the EU, which is different from making laws in the US. We take our time. People think, oh yes, they do AI and they rushed it. Well, we started with the EU AI Act in 2017, 2018, so it was not rushed at all. It's like 6 years of preparations. I mean, it was more than 2 years. We made the proposal in 21 in April, so about 2 years of, well, now more than 2 years of preparation. 3 years almost, because it's still not yet adopted, and we had white papers and green papers and expert groups and all of these things. So if we need to modify the copyright framework, it will take time. This is not something that like in a year or 2 years will be in effect. This will take another 4 or 5 years. So it's the kind of thing where and it's politically delicate. As I said, there's still people walking around. My colleagues in the Commission still wake up sometimes in the middle of the night when they think back about these difficult negotiations on the Single Market Copyright Directive 2019. So before we take the plunge, we want to be absolutely sure it's necessary, and that we actually, because if you work for the European Union, you have this sixth sense, we need a qualified majority. There's no point in taking a Ferrari and drive it into a wall. You want to be sure that you actually get the result. We have, at the end of the day, there's more people voting in favor than voting against, which in copyright is not a given. And also, this is not going to lead to a kind of the new framework will not be in place if we start modifying it for like another 4 or 5 years. So in the next couple of years anyway, we will need to find more pragmatic solutions. Part of it will be based on the European framework as we have it. Part of it will be based on like how we interpret it, and we may need to give guidance, etc. And then part of it will, of course, need to be settled in the courts when the courts kind of look at the legal framework in the European Union and see how it can be applied to kind of cases which maybe we didn't foresee when we were negotiating or conceiving and negotiating the legal framework, which now have to be adjudicated on the basis of the legal framework that we have. So maybe I'll stop here. I hope it's kind of not too complicated.
Thank you very much.
Yeah.
So I think one thing that I wanted to sort of observe is that there have been proposals in the United States also to adopt a kind of collective licensing approach to the use of in copyright works as training data. Of course, there are right now lots of voluntary licensing agreements being negotiated, and that actually seems like a good thing to have happen. And more voluntary licensing, I think, is probably likely to happen in anticipation of more legislative proposals about licensing as a way to say there are benefits from the existence of these trained models. They have a lot of useful things that they offer for people who are disabled, for enabling access to a lot of information for people all over the world. So there are benefits. So maybe we want to have some of these generative AI models to exist and to be available to the public. But at the same time, since the companies are making revenues, generating revenues from the use of the models, the idea that the artists don't get anything or the authors don't get anything doesn't seem fair either. But then it turns out that if you're going to try to design a system like this, that there are a lot of stakeholders, right? So when we're talking about other kinds of disruptive technologies that have been out there before, they've pretty much focused on one particular sector, but everything that's in digital form can be used to train models. And so how do you get billions of people, billions of dollars, and trying to design an effective collective licensing system? So it's an attractive idea, but trying to get the economics right would be, I think, a big challenge. So I did want to sort of mention that. I think another thing that the Copyright Office is going to be thinking about, and I'd be interested in your thoughts about this, Gerard, and that is labeling outputs. Should you, should companies that generate visual art of some sort, should they have to identify that this is AI generated, and should that be mandatory? Should that be voluntary? How do you develop standards that would then apply? And what do you do with all the AI generated content that's out there right now that ain't labeled? So those are another, I think, bundle of questions.
Yeah. I mean, we have elections in the European Parliament in 2 or 3 weeks, the beginning of June, and so you can imagine that there's quite some concern about fair, election integrity, and because of particularly the disinformation, and particularly disinformation and kind of manipulation of information from Russia and China. And so there is a very strong push. This is particularly around deep fakes, and we've had some examples. Tragically, as you will have heard, Robert Fico, the Prime Minister of Slovakia, was shot yesterday. But in the elections, that was like last September, a couple of days before the vote, there was what then later appeared or turned out to be a deep fake of it was not. It was an audio tape, where it seemed that the challenger to Fico was involved in some kind of corrupt activities, and of course we don't know because we can't compare, but there's some kind of belief that it might have impacted on the election. So there is so we're not talking about something that hasn't happened yet. There are examples, and so we are very much, and it's also something that the AI Act talks about labeling, watermarking, but watermarking is a particular technology, but at least to be able to recognize that what you see has been kind of is synthetic, that it's been kind of, AI has been used in order to kind of maybe change the picture or kind of created artificially the voices of politicians or whatever. So this is foreseen in the AI Act. It's not necessarily, this doesn't come from a copyright perspective necessarily, but it comes very much from how can we make sure that in the future we can still make a distinction between what is true and false, what's been manipulated and what's real. What is the facts and what is not the facts, and that in a democracy is, of course, that's at the core of a democracy. So that's something that the EU AI Act mandates. There's a lot of work that's going on how to do this. It's standards setting. There's the content provenance and authentication work that's happening also here, particularly led by Adobe and Microsoft, which we find very interesting. There's a bill in the California legislature sponsored by Buffy Wicks that's about these issues, which we find very interesting, where we're trying to kind of build bridges. But this kind of technology, or this kind of the way to identify that something is has been created with the help of AI, we think could also be potentially very interesting in the area of copyright. That if you see a kind of a particular, particular picture or
So we have only 5 minutes left, and I did
you
promise
want
the
questions
audience.
and answers? Then I stop immediately.
I did promise the audience a chance to ask a couple of questions.
Flies.
So
I'm just super curious, how will you implement the regulations for sort of protecting copyrighted or AI-inspired art? What will you unleash by accident the NFT market, for example? Because you'll have to train the data and have it licensed somewhere, unlike physical art and so on. So I'm just curious about what is the vision for actually going behind, whether it's consumers or businesses who are potentially infringing copyright.
Yeah, the implementation typically and enforcement in the European Union is decentralized. So it's done at the level of the member states. That's our typical model. And of course, we create rights in the European Union can be directly enforced before the court. So if you're an artist and you feel that your interests have been harmed or violated, your rights as laid down in the copyright directive, you can go to a court. And you can say, look, this kind of person or this organization kind of took my intellectual property. I wasn't remunerated for it. They used it, and so they are violating the copyright framework. You can get damages. You can get kind of compensation. So that's the way it is. It's working in the AI Act. We have it like a dual system because we are putting in place what is called an EU safety office that is looking at these models. We have two. The AI Act is about systems, like if you use AI for recruitment purposes or for financial services decision, whether somebody should get a mortgage or medical, where there's situations where you don't want bias, you don't want discrimination. That's enforced by the member states. But when we talk about the OpenAI, the ChatGPT 4, 5, the Claude model by Anthropic, that will be enforced by the European Commission centrally. And this is also where, like, if there's a problem, it will be addressed to the European Commission. The European Commission will, for example, the reporting that these companies will need to do about how did they train and how did they comply with the copyright directive. We will set out particular templates that they need to follow so that they report all in a pretty harmonized manner. And if there's problems, then of course the enforcement will be done either directly through the courts or through the European Commission. And this is serious enforcement. This is not, I mean, you don't want to get a phone call from the European Commission like we have some concerns about your compliance with the EU AI Act. I mean, there's serious like penalties that are foreseen. This is not small beer. You don't want to get on the wrong side of the law in Europe.
So my question is, many artists don't have the means and the time to track down how many giant corporations are churning up their data and using it. Yeah. So what is the EU doing about accessibility to, David versus Goliath type of situation?
Yeah. Well, I wanted to, I mean, I think the point I made about collective licensing is about that. I mean, we have representative organizations that kind of, and this is in music, this is in film, this is kind of across the board, that represent the interest of the authors. Because indeed, if you're an author, you can't just check what's today. I mean, you can't just be every day putting prompts into a large language model and see if there's some kind of violation there. But that's why we have representative organizations. And the point I made, I cannot see practically. I mean, if you're an author, I mean, you negotiate with OpenAI or Anthropic and all of these other kind of, because there's not only one or two, there'll be many more, and say, look, I mean, you have been using my copyright and now you need to be remunerating. This is, I mean, you're an artist. You want to create. You don't want to spend your time on checking whether your kind of creative, results or whatever are kind of used in a way that's not consistent with like the copyright law. So this is where we see in Europe a very important role for representative organizations and collective licensing organizations, also because it is David versus Goliath. These companies, okay, they're maybe not as big yet. These companies will be the future Google. I mean, Google is one of them, but I mean, OpenAI, and these will be very powerful companies. And if we have learned one thing over the years, if you put that big company, these giant companies, in front of like relatively, I mean, still big companies, but not, say, 1/100th the size of these companies. I mean, there's a little bit of power and arm twisting that's going on, and to expect that you get the best possible deal when you put David. David doesn't always win. I mean, it was just was an exception to the rule that David won against Goliath. But typically, when you put David against Goliath, the second, if you have him fight 100 times Goliath, he will lose 99 times. So this is like what you find into the Bible is not necessarily how it's going to play out in the future. So this is where you have to have representative organizations that kind of also have clout and have muscle and can kind of get the best possible kind of terms out of these big players.
In truth, almost all of these regimes end up benefiting the big publishers and not the individual authors. So the collective licensing happens through organizations that obviously take a slice to administer it. So not all the money gets to the authors. I think that there have been an effort on the part of the European Union to increase the ability of individual authors to get some compensation. But most of these directives actually benefit the big publishers more than
because they're big
than the individual authors. But I think we've actually run out of time. So thank you very much for your attention. And I think we'll probably be able to answer other questions. I can certainly be reached by email if you care about that. Yes. And thanks very much, Gerard.
Thank you, Pam. Thanks.